Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. Today, we're going to talk about the clean hands doctrine. The clean hands doctrine is an equitable defense that the defendant usually uses against the plaintiff, asserting that the plaintiff acted in bad faith. But today we're going to look at a case where the defendant asserted that the plaintiff acted in bad faith, whereas the court found that the defendant, in asserting that plaintiff acted in bad faith or had unclean hands, it was actually the defendant in making this assertion in his affidavit that he, in fact, had unclean hands. And plaintiff, pro se, you want to pay close attention to this. It's important how the defendant asserts that the plaintiff acted in bad faith or had unclean hands. All right, let's just get started. The clean hands doctrine says that whenever a party who, as actor, seeks to set the judicial machinery in motion and obtain some remedy has violated conscience or good faith or other equitable principle in his prior conduct, then the doors of the court will be shut against him, meaning the court will refuse to award him any remedy. I've cited a case, an old 1955 case, Franklin versus Franklin, that really explains the doctrine well. You should read it, but the doctrine itself will become clearer as we move through this video. To establish an unclean hands defense, a party must show that a party seeking affirmative relief is guilty of conduct involving fraud, deceit, unconscionability, or bad faith that is directly related to the matter in issue that injures the other party and affects the balance of equity between the litigants. So let's look at Katz versus Carlson. It's a 1948 case, an old case, but it really explains the clean hands doctrine well. Now, in this case, the husband obtained an order from the court vacating the final divorce decree. On appeal, the order was reversed. So let's go through this timeline, and I do want to take my time. Pay close attention to the facts. In January 1931, husband filed for divorce. Subsequently, they reconciled, and as a result, the complaint for divorce was dismissed. On June 1st, 1936, the wife turned around and filed for divorce. On May 17, 1939, the husband filed an answer to the wife's complaint for divorce and also filed a cross complaint for divorce and alleged community property. Of course, filing cross complaint, he asserts himself as a plaintiff. The wife did not answer the cross complaint. In September 1940, the husband served the wife notice of motion to show cause why her default to answer his cross complaint should not be granted. On September 18, 1940, the default hearing was held and the court entered an interlocutory decree of divorce in favor of the property. The wife did not appear, but the parties again reconciled. On September 30th, 1940, the Downey Street property was granted by deed to the wife by the husband. On October 2nd, 1940, an interlocutory decree on cross complaint in favor of the husband was entered. On June 30th, 1942, the husband, by affidavit, represented that the wife procured a final divorce without his knowledge. In essence, he testified by affidavit that she committed fraud. Now, let me say this. Sometime after the wife obtained the final divorce decree, she died. So, in the husband's motion to vacate the final divorce decree, he argued that the plaintiff wife had perpetrated a fraud upon the court in obtaining the final divorce decree upon affidavit now, stating, listen to this, that there had been no reconciliation since the issuance of the interlocutory decree. In fact, the court determined that the husband, by his own affidavit, had practiced a fraud in obtaining the interlocutory decree without mentioning previous reconciliations and without reference to the community property, the Downey Street home. The court stated, defendant did not inform the court in the divorce hearing that any community property was involved, and prior to the interlocutory decree as entered in the record, did not inform the court that he had deeded his joint tenancy interest in the Downey Street property to his wife. The court concluded defendant's motion to vacate the final decree should be denied upon the sole ground that the defendant and cross-complainant husband, same person, right, has, in legal parlance, proceeded with unclean hands. What's the takeaway here? When defendant moves for equitable relief, read the fine lines, read the defendant's affidavit and any other material that the defendant uses to get equitable relief. Make sure that the defendant's hands are clean. Hey guys, I hope this has been helpful. I am Advocate Lucinda, and we will see you next time. Take care.